is Atif Mumtaz. I am program manager at Northforge for Elevate IP. I'm just going to walk you through some of the slides of what is Northforge and what is Elevate IP that we're talking about. So as Whitney mentioned, we are an incubator and an accelerator. But beyond that, we've got lots of programs that are going on at Northforge. And one of them is Founders Program, where we take startups from idea stage all the way to Series A and beyond. We're also helping women founders under Women in Innovation Lab, WeLab, which we launched earlier this year. For international founders who want to move to Canada and bring their innovation to Canada, we've got something called Startup Visa Program, and under which international startups can now come and work legally within the US. We've got another interesting program called Advanced Manufacturing Lab. This is for entrepreneurs who are building hardware-driven ideas and products in our fabrication lab. And beyond that, there's a program that we just completed called Global Entrepreneurship Initiative. This program is meant, in my opinion, for every single entrepreneur who's trying to do business in Canada. This program actually teaches you how to do business, and it's for free, freely available to every entrepreneur in Canada. Just log in, sign up, and start going through the courses and learn various things as to how do I file taxes in Alberta versus Manitoba, versus if you have a client in, say, Vancouver and you're in Manitoba, how do you manage taxes? How do you register a company, local versus provincial versus national? These kinds of questions and many others are answered in this Global Entrepreneurship Initiative through online series of lectures. And along with all these programs, we've added one more, and that is Elevate IP. Now, when we talk about Elevate IP, we're talking about intellectual property, and it's not just patents. It's about everything under the sun. So that could include copyrights, your industrial design, your trade secrets, your trademarks, and even contracts that you're signing with your startups or with your employees. Who owns the code? Who owns the design when you build something, when an employee builds something at your startup? Do you own it? Does the startup own it? If you're using ChatGPT at the back end, or AI at the back end, or open source at the back end, who owns the intellectual property then? These kinds of so this program not only talks about these things as part of awareness, but also helps you connect with a lawyer to build a strategy and figure out what you own, what you don't own. And based on the strategy, as well as the awareness that you have gotten, we can then go into implementation where we can fund the implementation as well. Now, as far as awareness and strategy is concerned, it's totally free. It's covered 100% by Government of Canada. But for implementation, we cover up to 70% of the cost. So if implementation, let's say IP filing, patent filing costs you $10,000, $7,000 will come from this program. That's a huge benefit. We are offering up to $100,000 worth of funds, but initially, when a startup signs up with us, we offer $15,000 for strategy, and then another $25,000 for filing, and then case-to-case basis, you can come back and ask for more funds if you have another IP filing that needs to be done. But a total sum of no more than $100,000 can be spent per startup. We've talked about the 70% that is covered, and what type of startups qualify. Every single startup which is a tech, which has some tech component to it, qualifies and must show a revenue and employment growth rate. So in other words, it's not just an idea stage startup. It is actually into an MVP, building a product, or out there in the market really generating revenue. So just submit your pitch deck, show us what your go-to-market strategy is, what's your employment and revenue strategy, and if you're registered in Manitoba and Saskatchewan, you're ready to go. So we are right at the time when the program just got launched in November, literally last week, and now we are going to be supporting in the next 2.5 years 600 startups in Manitoba and Saskatchewan region. To register, it's very simple. Come to our portal, sign up, and you're all set to go. However, if you have any questions and you still want to learn more, you can always reach out to me. Uh, Before I move on to the next slide, I want to acknowledge that we have our partner from Bearskin and Par. Joanna Ma is our speaker, and she has a background in electrical engineering, which is very, very important. And she has been helping file patents and build strategies for startups in artificial intelligence, in autonomous vehicles, in cybersecurity, and many other fields. This would be good to talk to an engineer and learn from engineer slash a lawyer as to how to build your own strategy. So she is available for Q&A even after the presentation, and she will be visiting North Forge in December. I think December 6th or 7th timeframe. So if you want to meet in person, she's available with office hours as well. So over to you. Thank you.
Thank you so much, Atif. I'm just going to share my screen here. Okay. So thank you so much, everyone, for making time to listen to me talk. I will be monitoring the chat for any questions you might have as well, too. So feel free to enter that during the presentation, and then I'll get to it over the progress of the presentation. And as Tiff mentioned, I will be visiting North Forge on December 6th and 7th. And then I understand that some office hours will be made available should you want to chat more in person. I'm really looking forward to meeting more of you in person and getting to know North Forge more. So today we're going to be talking about your rights and understanding what your actual intellectual property can be. And what does that mean even? Like, what is your IP? So my presentation today is about 45 minutes to 1 hour, and then I'll look on for questions throughout. So feel free to have that presented during the presentation. My background, as Latif mentioned, is in electrical engineering from Waterloo. I'm currently based in Kitchener-Waterloo in Ontario. Breskin & Parr is an intellectual property law firm, which means that we specialize only in IP law. My background is in patent specifically. I also do a lot of industrial designs. And they're called design patents in the US. I'm a Canadian lawyer and Canadian patent agent, but I'm also qualified before the US Patent Office to work directly with the US Patent Office on behalf of Canadian applicants. And so, interesting enough, large majority of my work is actually directly before the US Patent Office, and just more so because US is a very, very IP heavy country. So even though we have offices in Toronto, Mississauga, Montreal, and Waterloo, IP law is federal, so we work with clients all across the country. I'm originally from UBC for law school. I grew up in Vancouver. I went to UBC from a law school, and so I actually do have a lot of clients in the West Coast as well as in California. And for any international filings, we can also directly engage associates we have good relationships with on your behalf. And so even though IP is jurisdictional, you will pretty much only have to interact with us. Going back to my firm, Breskin & Parr, as I mentioned, we specialize only in IP law. And so that incorporates patents, trademark, copyright, industrial designs, anything on the fringe of IP you can think of as well, too. So privacy is a huge thing. Data management, data ownership, any agreements relating to IP, so licensing agreement and whatnot, we can assist with. Elevate IP is an excellent program that launched recently, as Tiff mentioned, and part of the agreement development and commercialization plan can actually be incorporated under Elevate IP as well, too. Our firm, one of the main differences, our firm has over of the law firms is that obviously we specialize only in IP law, but we also have a very broad spectrum of patent agents, lawyers who have technical specialties in all sorts of tech. So I'm in the electrical and computer technology group because I have an electrical engineering background, but we also have people with mechanical background, with physics background, biomedical background, and in our life science department, we have people with PhDs in chemistry and biology and all sorts of life science technical degrees. And so when you're going down this IP path, I think one, especially if you're engaging in patent work, it's important to be mindful of the people you're talking to. It's definitely important to be able to at least have them speak your same technical language. I often tell my clients to treat me as their grad students. Teach me your invention at that basis. At least I can understand the foundation of that technical knowledge. And that's always a very important thing to keep in mind for IP protection, because being able to verbalize and describe your invention in a technical legalese form is how you can maximize the protection for your IP. But before I talk more about that, I wanted to give you a brief summary, an outline of what I want to do for the next 45 minutes. So really treat this as like an engagement of 101 of what patent or IP, intellectual property, may mean to you and your business. So I'm going to give you a very quick intro to the types of IP that are available, as well as a primer on what IP is to you, your business, and why is it important. And then we'll explore the different types of IP with respect to a case study, which is going to revolve around the iPhone. So that's the outline for today. So the introduction to the types of IP. So the core types of IP that you've probably heard about are trademarks, copyright, industrial designs, trade secrets, and patents. But how are they different and what does it mean to your business? So trademark, imagine trademark as your branding protection. Anything that your clients or customers would associate with your company in one way or another. So for example, your business name, your product name, which can be different from your business name, your logo, your slogans, any of that could be protected through trademark. And so one example on the right is Apple. So Apple is really a fruit. But nowadays, when you talk about Apple, the first image probably that comes to mind is some kind of fancy tech device. So an iPhone, for example. So Apple itself the company has done a great job of branding themselves to be associated with specific services and wares when it comes to the word Apple. They also have, and we're going to dive deeper into this throughout the presentation, iPhone itself, that term is the name of a product, and they have done an enormous, like a great job in making sure that it's specific to certain types of services and wares. And I keep saying the word services and wares, and I'll go into details to why that matters. But imagine trademarks as the way to make sure that your branding is well protected and you can own it in a way that you can commercialize from. That's what trademarks about. Copyright is used to protect creations. And so copyright, it's typically used for literary works, artistic works, where the moment you create that piece of work, there's a copyright attached to it. And so, for example, the Anne of Green Gables book, the moment it was created, there's a copyright attached to it. There's limitations as to how far copyright will lead in terms of you being able to maximize the scope in which you're protected just purely by copyright. And I'll explore what that is. But copyright it's embedded with its name. It's the right to prevent someone else from copying your piece of creation. And going into the final three, and this is what I specialize more in, it relates more to invention. So industrial designs protects how things look and feel. And you'll be surprised to learned, at least I was, that a lot of the litigation between Samsung and Apple related to the iPhone stems a lot from the industrial designs. I'm a Samsung user, so an Android users, and so anytime I pick up an iPhone, it actually does make me pause and think about how to better interact with that iPhone. It's a different user face. The phone itself is actually different in terms of how the buttons are positioned and how you can interact with it. And so industrial designs cover how things look and feel. Traditionally, the golden glass and the shape of it is how you interact with industrial design traditionally. But with the onset of more consumer driven product, a lot of the protection through user interfaces can be used through industrial designs. Trade secrets, another way of protecting inventions. But trade secret, there's actually no way of filing it, but you do need to take active steps to make sure that you protect your secrets with trade secrets. And I'll go talk more about that. And finally, patents. Patents covers utility, how things work. And so that can be traditionally machines, the operation of it. And what I specialize in is software patents, the functionality of how software operates on the back end. So that's the core basis of IP. So I'm going to go into depth about how these relate to iPhone product and what it may mean to your business. Before I continue with the presentation, I think it's really important to keep these questions in mind to identify and help you digest what your IP can mean to you or to your business. The first question I really ask my clients is like, what is it exactly that you do best? Like, what are you selling yourself? What are you marketing to your customers on? How do you distinguish yourself, your company, over your competitor? Effectively, what is that delta that you think will pull a customer to you? And if any of these factors are important to the continued success of your business, then you would want to make sure that you can protect it in one way or another to make sure no one else can easily copy that. And if they want to use it, they can license it from you. So intellectual property is really a way to create a property, a value, a type of property that can assign a value, can transfer, you can license from, and for you to commercialize your product in a way where others can't come in and copy exactly what you're doing without having to, without being able to benefit from, without you having to be able to monetize from that. And also, the IP itself can protect your brand, which is related to your business reputation. So all of that together is a way of improving the value of your company, to protecting your company from others being able to easily copy, and just to generate some kind of value, a transferable right for your company at the end of the day. So today's case study is the iPhone. And so I'm going to talk about the different types of trademark, copyright, industrial design, trade secret, and patent that revolves around the iPhone. We're going to start off with just trademark. And so trademark, anytime after it's you apply for it, it's actually available for searching on the trademark database. And so one of the due diligence that I often recommend my clients to do is to go on the Canadian Intellectual Property website. There's a trademark database, equivalent in the US is available, and just do a quick search of either the company name or potentially the product name that you're playing around with. And before investing in more marketing money into it, and just to make sure that there's no clear barrier to you being able to use this trademark for the services and wares you want to pursue. I know it keeps emphasizing these services and wares, and what does it really mean? So this listing, it's just a screenshot from the Canadian Intellectual Property site after I did an iPhone search. And so you can see that there's application numbers here. These are the registration numbers. And so iPhone here, it's a registered trademark for specific classes. These are niche classes 9 and 41. And so you expand on it, you'll see that they're related to, 41 is related to services within the list here. And then iPhone here, which is related to a design mark here with the logo, it relates to services beneath class 9, 28, and 38. And so 28, it's another subgroup of goods and services, including goods for handheld, mobile, digital, for playing electronic games. And so you can see that when you're applying for a trademark, you need to specify exactly what kind of services and goods that mark or slogan or logo is going to be specific for. And that's part of the expertise that we can help assist with in defining the scope in which you would have your trademark for. And you can also see that iPhone takes a trademark very seriously. They have trademark applications for pretty much each of the iPhone, they have a trade dress for it. It was withdrawn. Trade dress is a different type of protection, which we can explore later on. But you can also see they have a lot of design marks. Obviously, Apple has a different budget when it comes for IP, but you can understand that trademark is specific to a type of good and services. And in defining the listing of good and services, you can better gauge or better protect your business over time. And why I mention that, it's because trademarks, when executed and protected properly, if you renew it, you can actually have that trademark protected forever. This is one of the unique differences between the different types of IP. Trademark, initially the protection is for 10 years, but when you renew it, you can keep, and if you use it consistently, the same trademark, then you can actually keep renewing it and you can have that protection for forever and ever. And so it can be a very powerful type of protection to have. And as I mentioned before, trademark is associated with the branding. And so on top of just protecting yourself and your reputation, and make sure that anyone else who tries to enter your space related to your goods and services, who tries to use a similar logo or name, are prevented from doing so. In Canada, trademark is actually possible. You don't have to register for it immediately. You are able to develop a common law protection for a trademark. And the reason why is that it's common law. So the moment you start using that trademark in association with the specific services and wares, you are developing a distinctiveness for that term or the logo in respect of your goods and services. And so you're developing the association with your brand for that goods and services in your area. The biggest difference in between not registering and going through the registration path is that when you're using it before registration and developing that common law protection, you're actually just developing a common law protection in the area that you're the local jurisdiction. Versus if you were to register, if you go through the registration path, after you have the trademark registration, you have a presumed right across Canada. So often or not, I use the example for Joanna's Bakery. So that's like something I've always wanted to do, to open a bakery and sell my baked goods. Some kind of local bakery named Joanna's Bakery, for example. But if I were to start that in Ontario, I developed that branding in Kitchener-Waterloo, where I'm based, and expanded such that people in Cambridge start understanding and recognizing my expertise or my branding with these big goods. Potentially, I can say that I have common law trademark protection for Greater Toronto area. But if I were to then go to BC, or if someone else were to go to BC and start Joanna's Bakery, because I haven't registered my trademark, I wouldn't be able to assert my rights limited to the Greater Toronto area against that Joanna's Bakery in BC. And so that's the biggest difference between registration and relying solely on common law. As I mentioned before, trademark, I would suggest definitely before pursuing marketing dollars in it, is just to do a clearance search. That is also one of the items possible to be covered under Elevate IP, is to make sure that at least your intended trademark is not going to be so easily similar to something else already registered in the database. And so I would suggest like at least doing a quick search on your own to make sure nothing immediately the same. When we do clearance searches, we look beyond the trademark database and identify anything that even sounds similar and could potentially be a barrier to you obtaining fuller protection for those services and wares before you engage in the business cost of marketing your branding based on that. So that's effectively trademark and what that means for you and your business with respect to the iPhone. And so going forward to copyright. Copyright covers, as I mentioned, creation. So some example of copyright protection that Apple has registered for is related to the emojis. And so these are registration from 2018. As I mentioned before, copyright, the moment you create it, there's a copyright attached to it. And so what's really important for copyright is that you keep a good track record of anything you intend on relying copyright for internally and mark it up. You can often see the C with the circle around it as copyright with the date on it. So it's actually not something I would all recommend clients register immediately. It's not very expensive to register, but at the same time, it doesn't really have a huge value with registration immediately. If you were ever to enter a litigation, if you were to enter a lawsuit against someone based solely on copyright as one of the claims, then you would definitely want to register that before entering a litigation. As I mentioned before, copyright relates to the exclusive right to prevent someone else from reproducing the work in whole or in part. So the legal test really is whether someone else has taken a substantial portion of your work. And when it comes to copyright, as I mentioned before, it's typically or traditionally used for literary works, artistic works, dramatic works. One of the, I think, myths about copyright is that with respect to software patent or software code itself, you can rely copyright on for protection. And how I try to explain the difference between copyright protection versus patent with respect to software code is that you need to analogize the scope of protection limited to copyright to code and literary works. And so imagine if someone were to just take a significant portion or some portion of your code and then change it into another computer code or understand the functionality of your computer code and then do it independently. If you rely solely on copyright for protecting your software code, then that's copyright wouldn't prevent someone else from understanding the functionality of your code and implementing it in a different fashion. Whereas software patents would cover the functionality of what that computer code is achieving and to prevent someone else from doing that same functionality. Another difference between copyright and patents is that copyright requires you, when you're trying to assert that right against someone else, to show that that person has had access to your piece of work. And so with respect to software code, you need to show that that person has had access to your computer code in order for you to assert your right against that person. So for the purpose of protecting software algorithms, software code, I wouldn't really recommend relying solely on copyright. You need to explore how best to protect that with other forms and specifically patents. Going to the question in the chat about copyright in AI. In terms of AI, it goes AI at the end of the day. There's data sets, the training data sets, there's the ML model, there's the algorithm in terms of how you're applying the ML to generate recommendations and potentially how you're training the data sets to generate the ML. All of that really is in how the computer function. The copyright itself is in potentially the data You have the algorithm, as I mentioned before, but copyright itself is really insufficient to protect AI applications specifically. So I wouldn't really rely solely on copyright for that purpose. Um, awesome, thank you. Going towards industrial design. And so industrial designs is the term in Canada. The equivalent, it's called design patent applications in the US. And so what it covers is how things look and feel. And so the example here from Apple is that the phone itself is shown in solid lines. And so anything and so industrial designs are through pictures, a lot of figures. And so anything shown in solid lines here, the buttons here, the holes, the reception, the cable adapters, and the speakers and mics, the holes here, they're all shown in solid lines. So this is what the industrial design registration here covers. And only one of the figures shown, for example, here, but there will be views from all different sides. The best approach, one of the recommended approach for design to maximize design protection is to layer the approach where if potentially certain buttons here are not so essential, you have it shown in stifle lines. So on the retail display unit group here, you can see that some of these are shown in stifled lines, on dot and dash lines. It means it's just shown for environment. It's not part of the design that's being claimed here, but it's just showing how potentially it's used in retail space or in actuality. Um, as I mentioned before, industrial design has gotten very popular with respect to more user interfaces, more consumer-driven products. So UIs, especially the ones where you have invested a lot of time and energy to making it very user-friendly, has industrial designs are a very good way of protecting that well. Industrial designs are used to cover how the features relate to shape, configuration, and pattern or ornamentation traditionally in a finished product. But with respect to UIs, if there are certain features of it that in some ways, when a user sees it and knows, hey, like that's related to your business. So it kind of links back to branding in some way. If you've done a lot of development work to making that UI very user friendly, and then that person, when they engage with your UI, will know this is associated with company XYZ. I know it's because of these certain boxes that are made in this UI, how I interact with it, then it's something definitely to explore as one way of protecting your company. As I mentioned before, I'm an Android user. And so one of the differences I sense whenever I open an iPhone is that the UI is very different in terms of how you engage with the different apps on it. And so that's actually driven by some of the design patent protection in place by Samsung and Apple. The term of industrial designs are up to 10 years. You get it for 10, and then you can renew to extend it to five more years. Therefore, really anything that you can protect through how it looks and feels. So none of the functionality aspects, but you can see through the iPods here how it specifically looks. Like you can see these are the stippled out portions, and the interior it's stippled out, so as we don't want to limit exactly how the interior is. And then this is one of the Lululemon signature sports bra. And then so the back, in terms of how they had the elastic intertwined, has been protected through industrial design. It's industrial design are a really interesting way of, I would say, complementing your patent portfolio. So Nest products were actually developed by ex-Apple employees, and so they took design to another level of protection. And so they made about a quarter of the Nest portfolio back before it was acquired by Google relates to how things look and feel. So they had a large UI design protection for the Nest thermostat UI itself, as well as the Nest carbon monoxide and smoke detector. And so they had spent a lot of effort in making sure that the products they are putting in the consumers' homes look and feel a different way. And so as you interact with it, you are associating that product with a specific brand as well too. And anything that you would help a user engage with a lot more and makes it more difficult to prevent that person from moving on to another product. Industrial designs are a really powerful way of maximizing that protection. Trade secrets. And so trade secrets, obviously, if we had known what iPhone's trade secrets are, it would no longer be a secret. So trade secret, it's embedded in its name. Like you can use trade secret to protect anything that you can keep a secret effectively. So the traditional way you protect recipes, for example, are through trade secret. Although there are no filings you need to do to take advantage of trade secret protection, you do need to take steps to make sure you protect it. And what does that mean? And so the example of KFC is an interesting one. So the KFC spice recipe is protected through trade secret. And what they have done to make use of trade secret is that each of the different spices that are mixed together to result in that final mix of spices, they are brought to a factory A in unmarked vats mixed together, and that mix is then brought to another factory with another mix together that results in the final mix. And so the idea is that no one personnel at one factory would have easy access to the full mix of spices that goes in it. They don't have easy access to the exact ingredient that is in the unmarked vats. And so they have taken physical and barriers to making sure that there is no easy way, and they're limited to the knowledge essential personnel. So going to the example of MySpace, for example, where I software protection, and how do you make use of trade secret? I would say that trade secret is it's a really good tool during the early development of software protection, where you're not launching yet, you're not even doing pilots, where the code development is in-house. You have it on a separate server. Not every single employee and a random person coming in can get access to it. It's on a password protected server. Only essential people who are working on that code has access to it. It might be that components of the code are stored separately as well too, to limit access to the full piece of code. And anything else that's very difficult to reverse engineer is a good way to rely on trade secret. And so recipes, obviously, it's a really good way of using trade secret to protect that. Data is a really good way of protecting through trade secret as well too. But it's important to understand the risk of us relying solely on trade secret. And so Dr. Pepper's example is it's interesting in that the the older recipe of Dr. Pepper was actually found inside a used book, sold through a used book sale. And so the full recipe was given at that point. And so even though it wasn't stolen, it was disclosed randomly, pretty much. But through that disclosure, that trade secret is now no longer available. And so you have to understand what you're protecting with trade secret and what vulnerability you have. Because even though you have contracts in place with employees, if they were to depart, there is only so much you can control in terms of what they share with the next employer. Your contracts with them could probably limit how much they disclose from your company. But once they're at another company, you just cannot really control that until that product is available through the other company and potentially a competitor of yours. And so with trade secret, it's really good for a certain limited time for computer code, for example. It's really good for recipes, data protection, business data information, and for you to keep a really good record of it as well, too. Like obviously you don't put all the secret sauce in one server and one listing, but a documentation listing of generally what that information is. And that's actually a one really good due diligence point, and especially later on down a pathway, you're going to do due diligence with investors and potential buyers for them to understand that trade secrets are part of your IP that is being sold, and this is what you have available. The risk associated with them is that if you decide to rely on trade secret to protect your software code, if someone else were to independently make a similar functionality, that person can then pursue a patent for it. But because you never disclose yours, you are not able to challenge their patents because you had rely on trade secret. It also doesn't protect against independent discovery on the same line. And so there's a good balance in play where you can rely just on trade secret as well as other types of IP for different types of innovation. So I'm just going to answer some questions while I have it. The first question from Jeff is, would you consider a 3D concrete printed wall as an industrial design? Potentially, yeah. If there's uniqueness in how it looks and feels, definitely there's something we can look into as well. But it does require some uniqueness in how it looks and feels. So maybe there's some texturing, how certain, like how it seems together between the different concrete pieces. Potentially there's something unique there, but it does need some uniqueness against everything before you. So industrial designs, it's in the industrial design applications in Canada, but they're called design patents in the US. And so the novelty requirements and obviousness requirements to obtaining a patent protection still applies. It does need to be new to the world. So potentially there's something there. Do research, and Guy asks, do researchers have any protections against suppliers from reverse engineering their research? Yes, and so that's a really good question, and then I will get back to you actually on that later on during the presentation as I talk more about the legal agreements point, but I'll definitely get back to you on that one. And finally, going to patents. And so with the iPhone, there's actually tons of patents surrounding the iPhone. Patently Apple is actually a website that we kind of look on from time to time. It lists all the recent publications of patents that Apple has filed. And so one of the interesting things that you'll learn over time is that a lot of companies, especially the large one, or even some other companies, they like to file patent applications for any innovations they have, but you might never really commercialize it. So what's interesting about seeing the patently Apple publications of the patents that are recently published or patent publications that are published is just to see potentially what you might see on your iPhone in the coming years. And so the first one on here is electronic devices sidewall displays. And so I have to admit, I'm not a patent user, an Apple user. And so this one, I'm not entirely sure if they have it, but it's a display having a first pixel area, a second pixel area, and a third area, and interposed on the side, the mini flexible edge display there. So they had, what's interesting is that I'm not going to super detail about this, but the priority date for this patent application is actually 2011. And so there's a unique type of filing in the US called continuations. And so a lot of the patents you might see, even though they might relate to really the similar topic, the claims are different. And so when you get a patent in the US, you have the option of filing what's called a continuation. And that continuation can be used to broaden the scope that you have obtained through the patent examination route. And so what Apple has done with this case is they had filed one in 2011 and they had kept a continuation pending. And so this is the eighth patent that they has issued from the same line of documents. And this is actually really highly recommended for a lot of companies. And I do that for a lot of my clients as well too, where budget's available. The reason why is that once you get a patent for the first iteration of protection, you might want to keep one pending so that you can wait to see the competitive landscape. It might be that 2 years down the road, a competitor comes in and they do something slightly different. And then you can adapt, arguably, hopefully your patent supports, your patent application supports that. You can adapt the claims to make sure that it targets that competitor product more intentionally. And so having a continuation pending is actually a very strategic move. And so what Apple has done here is kept a case pretty much pending for 11 years. And they're still growing that. And what's really powerful about that is that any case growing from this line of patent application will have the priority date of 2011. And so only prior art before this 2011 date can be used against any of these later applications, even though one is filed in 2022. So within the patent world, the filing date is key. So the priority date here is key. Something to think about as well too. And then on this one here, electronic devices with flexible display cover layers. I think we're seeing more of this kind of phone come into the market where you have bendable and foldable screens. But you can see that it was filed first in 2019. And only in the recent, I think in the recent 2-3 years, did you see it more in the commercial marketplace. So it's always interesting to see what kind of new patent applications are published. And another note is when you file for a patent application, it actually doesn't publish for 18 months unless you request it to be earlier published. And so even though you're seeing a patent publication now, this has been in the works by the company like more than 18 months ahead of that. So it's an interesting thing to keep in mind. Like filing first is really key, and having that early priority date and within the patent world. So really, what does patent mean for you? It covers the functionality of technology. You can use that patent right to prevent others from making, using, selling, including importing of that patented invention. So at the end of the day, the idea of the patent system was developed or introduced by the government to give you a limited time, a monopoly to prevent someone else from doing these things for a term of 20 years. And after that, the idea is that that patent right becomes public domain. It's owned by the public and for others to practice that invention. The power of patents is that it covers a functionality. And so that's why when I began my presentation, I emphasized that it's really important when working with patent professionals to make sure that at least they can understand your technical language. To properly protect your innovation, you do need to be able to understand the invention, understand how it works, and to help you and guide you down the path too, because the term of a patent is 20 years. And even though you have your iteration one of your prototype or your software code or whatever else you're developing, you want to think at least in the next 2 to 5 years to see what the next step is in terms of product, where's your business heading, to make sure that the patent application you're pursuing now could protect to protect your company for those next 2 to 5 years at least. So that is something to keep in mind when working with a patent professional, for them to understand the core technology and to ask you the questions of like, what are you planning next? Like what is in the next few years of what you want to expand into, the different types of industry. But what does that, and even if you go into this industry, does that affect your core technology? How do we make sure that we can protect that well? Even if you don't intend on going into that industry, can you license that technology for that industry? And you can have other revenue coming in other forms. So with the patent protection, it can be very powerful when executed in the right way. Just keep that in mind when considering whether patent can be right for you. I'm just looking at some of the questions here. How can you protect a slightly different variation of your industrial design? That's an excellent question, Amit. Um, that's why it's very important to work with professionals who understand the power of design patents. With design patents, it's through just drawings. It's very easy to submit drawings showing your current prototype. But what's difficult is to think about how others can easily copy it or design differently to not infringe on that design. And so you can submit the first iteration of what exactly you're doing. And you can also submit additional drawing sets, which are called variants. In any of these countries, it just costs a bit more depending on which country. And those different variants would have aspects that you think others would not necessarily have in their designs in dash lines. And so that gives you the layered approach. So you have to think about at the end of the day, what is it exactly that core design element that you will have no matter what in any of your product lines, and any usage of your products and anyone who copies it. And then how best do you protect that? So it's a layered approach, and to make sure that you have that conversation and think down the line as to how your product may evolve. I wouldn't recommend design patents or industrial design protection until you have a pretty good, solid idea on what the final product will look like. It's just not really worth the money until you have a pretty final version of it. Otherwise, it can be fairly easy to design around by others. Um, in terms of like what if I'm filing a patent, but someone also files a similar patent around the same time in another country? It goes down to filing dates, and it doesn't really matter what the other country is now with the international. So patents are jurisdictional. If you want protection in one country, you have to file in those countries. There are ways where you can delay the decision making a lot. In some ways, depending on the type of filings you do, and we can assist with that. But anything before your filing date is fair game in terms of citability against your patent application. And so on that note, I'll go back to this graph for a minute here. This is a high level process of what we do when we engage with a new client. The first step really is in helping you define your invention. A lot of times, startups come with us with a really great idea and a really great business plan as well too, to how to implement it. But a lot of the times, you'll be surprised to see that similar ideas have already been disclosed in one way or fashion within the patent space, even though you haven't seen it commercially. Filing for a patent application is way cheaper than ever commercializing and making a business out of an invention. And so we work with the clients to understand in detail of what the invention can be. We dive deep into variations of it. And so through these Elevate IP funding programs, and when we work with new clients, we work with them to mine for information. We look into what you're doing as iteration one. What is the future of where you're heading as a business and what that technology can be? And dive deep as to what that invention is. So we work with you to mine for invention. And we often recommend a patentability search. And so the idea of patentability search, goes to T's question, is to try to help you assess the risk you're engaging when you're going down this patent process, and to make sure that the patent you pursue is as strong as possible. So it's kind of like a risk assessment to see what is there out there before your filing date that can become a barrier to you obtaining strong patent protection. And so a patentability search, I often recommend clients do initial ones on Google Patent. Google Patent is a really great interface, a search engine. And you can conduct a search as to what is there within the space, see what has been disclosed. Patents aren't actually like that fun to read. This is my day job, and so I wouldn't really recommend them as bedtime reading, but you're able to kind of see through the drawings potentially in the description of what they're pursuing, and it gives you a good guidance as to how busy the space is. We can also assist with patentability searching. We do this every day, pretty much. And so we know where within patent application to read, what it means to you. And so that really gives you a good guidance as to how strong your patent application can be when you go down that route. Some of the limitation of patentability searching is, as I mentioned before, when you file for a patent application, it's actually not published for 18 months. And so when we do a search, we're limited by the same issue in that anything filed by anyone in the last 18 months we can't find. And so for in the past years, for technology related to like applications of AI, I didn't really trust a lot of the patentability searches because there were tons of cases being filed in the AI domain. And so with patentability searches, like I unlikely will find anything related to that space. So it depends on technology. I do recommend it most of the time just to give you like a sanity check of what you may encounter in terms of barriers to you obtaining patentability. In some ways, it kind of mimics what the patent examiner will do down the line. Patentability search is optional. As we work with the client to figure out the invention, we then can work together to prepare and file a patent application. As I mentioned before, patents are jurisdictional. So depending on where you are, we'll talk generally about where your business may be, where you plan on selling, where you plan on entering into the market internationally. There are ways to maximize your timeline in terms of where you can go into later on down the road. And so we can discuss what makes sense. There are ways to delay costs as much as possible too for the regular filings. And so we'll talk about strategy as well too at that point. Once you have a patent application filed, it will eventually enter an examination stage. And I say eventually because this process depends on jurisdiction. So I'm going to stick with US just because it's more straightforward. And so with the US, once you file a regular patent application, it automatically enters a queue to be examined. And so when it's picked up by a patent examiner is usually a person with a background similar to your technology. They're all organized in different art units. And so what they will do is kind of what you would have seen done in the patentability search. They conduct a search of the prior art that were available with the filing date before your filing date to see whether your invention is new to the world, and that's a novelty conversation, whether your invention may be obvious, and that's a legal test. It's pretty great in terms of whether it's obvious in view of a couple of documents that they have found together. Most of the time, it's a stretch in which the examiner have potentially even applied different art units of prior art together to arrive at yours, but it's the negotiation at that point of your patent rights with the examiner. A lot of time we spend explaining to the examiner what your invention really is, and it's typical for any applicant to receive at least maybe 2 to 3 examination report until we get a really good sense of what scope the examiner may allow. Typically with the US, we do a lot of US examiner interviews as well too to help expedite the process. At the end of the day, they're humans as well too, so it's nice to have that conversation going. And then most of the cases, we would get to a good point where we understand what scope the examiner will allow, and at that point, it's just a matter of paying for the issue fee, and then you'll get a US patent at that point. This process is kind of similar for all jurisdictions. It just depends on the formalities required. So that's the patent process. And in terms of one of the biggest takeaways, I always emphasize to new clients, confidentiality is key. For patents and industrial designs, in contrast to trademarks, is that the best practice is to keep everything confidential until you file something. Anything under a non-disclosure agreement is okay, but at the end of the day, just use your your gut when dealing with anyone under an NDA, because honestly, at the end of an NDA is just really a contract. So how likely is that person to breach that contract? Do they even understand what that NDA really means? So make sure that, I mean, I always say to clients, like, blame the lawyer when you're making them sign NDA. Just say, like, hey, like, I can't talk to you any further until you sign this NDA. Like, my lawyer is just making me do this, because it protects you. And when you're making someone sign something, it makes them think about, like, do I really want this conversation? What is my obligation or responsibility after signing this? And so another takeaway with NDAs is just to make sure that it's restricted to a specific purpose and that both parties understand that this conversation we're having is confidential. And why we emphasize that it's important to keep your invention secret is that the moment you spill the beans or talk about your invention outside of an NDA, outside of a confidentiality setting, is that you could limit your rights. And so in Canada and US, you actually have 1 year grace period from your initial disclosure of your invention to file for patent protection. But in other jurisdictions like China and Europe, for example, it's absolute novelty countries, which means that the moment you disclose your innovation, what you want to protect as through patents and industrial designs, you are barred from obtaining patent protection. So keep that in mind. It's really important to understand the risk you're engaging, and sometimes you have to talk about things, but then if you can put an NDA in place, that's ideal. So I'm just going to finish the patents before going back to the questions. And again, patent searching is another really good due diligence point. Google Patent is it's a great interface to do searching. It's grown a lot in past years. And we actually, when we do searching for clients, we kind of start off with that before we go back to our subscription of patent searching tools, which is much more powerful. But Google Patent is a good starting point to get some keywords going. And then so go back to questions. When disclosing my business idea to potential investors, what steps should I take to protect my intellectual property? How do I ensure that my idea is not being stolen or copied by an investor? Yeah, so that an NDA is key. Knowing who you're working with is key too. A lot of times, the extent in which you're talking to investors is probably not going to be the secret sauce you can protect through IP. The crux of your invention, you probably won't get to that detail to the extent, but I would always be cautious of who you're talking with. Legitimate investors and VCs are usually willing to sign some NDAs, and if they want to get to the due diligence point or where you get more information to the crux of the invention, then they're more likely and willing to sign the NDAs. And on the other side is if you're talking with a lot of people and you're getting to a point where you're getting a lot of interest, then you probably really want to explore how best to protect your IP through one of these types of filings. Having the patent pending status can help with investment evaluation as well too. So it's good to understand the risk and be able to balance that as much as possible. If you're a small business and your research is drawing attention from large companies, how can you protect your own limited finances? That goes back to the other questions. Managing what you're disclosing as much as possible, having NDAs in place, and making sure both parties understand the limitations of NDAs, right? Like by signing this NDA, you're accepting that what we're talking about under this NDA during this conversation is confidential. You can't just go on and then start telling like the next person you talk about what we talk about here. They need to acknowledge that. And so some of the best practices in terms of NDAs is that when they're signing it, and any materials, written materials especially, you note everywhere that's confidential. And then have them acknowledge that by signing those documents and saying, like, I acknowledge that this is confidential. I will not share with anyone else. And so I think those are best practices to instill in your company as a whole too, because I think having that instilled earlier, make sure that everyone understands, employees, that everything you're doing is intellectual property. It's owned by someone, it's owned by the company, and they can't just take it all or take parts of it or whatever they contributed to another company and start sharing that and contributing to that other companies. That the entire concept of IP is that it's stopped, but it's also assignable to someone else. And when you're working with an employment situation, all the IP you generate through that employment is owned by the company. And so I'll go into more detail about that through the next slides. And the next question is, how can I protect IP rights in a couple of countries? Are there international treaties or agreements that I should be aware of? And so, yeah, absolutely. So there are ways of delaying the decision making on different countries. And so there's a treaty called Paris Convention where most of the countries in the world are subject to, most of the main countries. And so, which means that if you file a patent application in one country, you would have 12 months, so 1 year from that date to then decide exactly where else you want to file. And so typically we start off the US just because it's a much more prolific jurisdiction for patent filings. And then from there, you would have 12 months from that date to then decide which other jurisdiction you would pursue. There's another type of filing called the Patent Cooperative Treaty filing. It's a PCT application. It will never become an international patent, but what it does is it's in some ways it's a placeholder for you to then file elsewhere. So if you file the PCT application as your first case, you will then actually have 30 months from that date to then decide exactly where you want to go in the world. Most countries in the world, like the dominant markets, are part of the PCT, but there are some that aren't. And so early on in your engagement with your IP counsel, you should point out the countries that you're likely interested in. And that's part of the initial conversation in terms of the patent filing strategy to how best to maximize scope and reserve the scope available to you for patent protection. These are great questions. Thank you. What legal actions can I take if someone infringes on my IP right? Yeah, so that depends on what kind of IP rights you have. Ideally, hopefully, if it's patent rights that you have it filed, because otherwise, then it's you don't have any patent rights to assert against someone else. So it depends on what kind of rights. But cease and desist letter is typically the first step. We can assist with that to generate and evaluate the IP as well too. And depending on what kind of IP, we can offer advice as to how to strengthen your stance from the IP perspective as much as possible too. But yeah, like IP is a right. It's something you can use to stop someone else from doing something that you have defined as your monopoly. And so it is a legal document. When filing a patent or registering a trademark in Canada, what are the differences if the applicant is a Canadian citizen versus a non-Canadian citizen? There's really not so much in Canada. The only biggest thing is for us to act before the U.S. Patent Office directly, it needs to be a Canadian applicant, and the applicant can be a company as well too. So that's something to keep in mind, but not so much for filing in Canada. When is the best time to file a patent, before or after launch? I think just going back to our other question in confidentiality, the best practice is to file for a patent application before launching and before the product becomes public for sure. As the best practice. Yeah, please keep the questions coming. Those are excellent. And I think I've gone through all of them. So confidential information and IP rights. So again, just going back to patents, trade secret, best practices, confidential information is really key. It's another type of IP for your company. So best practice, again, keep your invention secret until you file for patent application on industrial designs. But there are, as I mentioned before, like there's so many. As a startup, you're required to do so many things at the same time. And so there's only so long you can keep something under wraps before you have to talk a little bit more about your invention in order to get to that next step. And so NDA is a really good practice. And we can obviously help and assist with that as well too. I've reviewed a lot of NDAs in my career. I think the biggest takeaway is to make sure that the NDA is short and sweet. It doesn't have to be a 20-page document. It can be very simple. Our firm has templates that we often use for clients. But the biggest thing is to make sure you limit it to a specific purpose. If your NDA is intended to just knowledge share potentially between two companies that's going to partner, then you should have that in your purpose, so that the scope of the information that will be kept under this NDA is it's a reasonable scope. So both parties enter that agreement, understanding what is confidential. And also, if you're opening up your sites to visit, to make sure that anything, if you're whiteboarding a really great concept that we plan on developing in the next months, put that whiteboard away, right? Like tidy it up. And so you try to limit the confidentiality exposure as much as possible. And these are just things to keep in mind. And happy to share my slides after the presentation as well too. Anytime you engage with external parties or even internal through employees, think about the IP being generated or shared, and think about at the end of the day who owns what. Employees, you typically will have some broad language where anything they generate within the employment will be assigned to the company immediately. And these are all really good clauses to have very early on in your startup life, just because down the road, it's only when you have a lot of success when these things come back and haunt you if you don't have it right. And so having all these IP clauses embedded or ownership defined between all these contractors and partners is very key to making your life during due diligence with investors or any other buyouts and whatnot down the road much more straightforward. Having a really good set of templates early on is great as well too, because as some of you may have encountered going through due diligence with investors, they're going to ask you what IP clauses, what employment agreements, what other contracts these parties have signed. Give me examples of them, and they're going to evaluate it. And so if you have just one really good agreement instead of variations of 10 or 5, like 10 or 20 of them, then it makes your own life very easy. And you can definitively tell these people, like, yes, everyone has signed this. They all understand how the IP is all managed at this point. And some of the other terms to keep in mind when thinking about contracts, when developing these relationships with the contractor. I mean, the agreement itself, it's left to the lawyers to finesse, but these are some of the business points to think about when engaging with potential partnerships as well. So I'm nearing the end of my presentation. So what I hope you have taken away from this presentation is that at the end of the day, IP strategy is just really one part of your business. It should be aligned with your business, and it can be a good way to attract investors. It becomes assets for your company, and it should help you grow your company over time in one way or another. Align your IP strategy with your business goals. I cannot emphasize that enough. IP should not just be a cost. It should be a way for your company to get revenue in another way. It should be a way for your company to protect yourself and to help your company grow without any other competitor from being able to shortcut your success. So definitely think as you grow your business, as you reach another huge milestone in terms of product development, potentially another flush of investment, reevaluate your priorities from the IP perspective, reevaluate your markets over time, and see, like, even though if you start off your startup and just filing for patents in North America, maybe in the next 5 years, you're actually entering Australia. So you need to evaluate and change up your plan at that point. And potentially, if you're going to Australia, probably New Zealand is another possible market that you're entering. So evaluating and changing up your IP strategy over time is key. And again, thinking about IP as a way to protect your company, to grow your company in different ways. IP, again, it's a way to add value to your company. It shouldn't just be a cost. So these are some of the typical uses. It's not one or the other. You can do a combination of a licensing deal while also trying to develop more IP to maintain a competitiveness, to engage more sales. And so it's not limited to one way. It could also position yourself. This is something to think about too. If your business is more of a product, but you offer services to complement it, and you might eventually want to sell off the product, then you might want to separate the IP surrounding that product so you have a different product name. The trademark is separated as well too, so that you can sell that off without impeding on the services that you're going to offer related to that product later on down the line if you retain that services component of your business later on, and that's your goal. So think about how your business will evolve or what your eventual goal is down the line. It might not be today. You think about it maybe like 5 months later as you engage more partnership or different types of clients, and just keep revisiting how your business strategy may affect your overall IP strategy. And again, think about the future. What's next for everyone that can impact your IP, your business, and see what that means for your IP strategy. And this is just a really quick summary table of different types of IP and how it may affect you, what it means, and the overall cost at a high level. And that's the end of my presentation. Thank you so much for being such a great audience and your questions. I'm not sure if there are any others. I'm happy to take on more.